Thanks, Nolene, and thanks for the invite to be here today, which I'm certainly very happy to have accepted. Clearly, FLAC are an extremely important stakeholder in the overall process and very much positively contributing to the general debate around this area, and equally as important, a trusted advisor in effect for debtors who are in difficulty. And as I said, more than happy to be here today. And I should say also happy to be joining Chris and Colette, two people that the Insolvency Service are working very closely with, because clearly there are a lot of crossover issues between the ISI, the Insolvency Service that is, and Chris Lahan as official assignee, and also with Colette in terms of the approved intermediaries and the role that they will play when we're in effect open for business, which, all things going well, will be by the end of next month. And I should say also that the government have announced that they hope to be publishing legislation within the coming days to ultimately see the transfer or merging of Chris Lahan's office into the Insolvency Service, to ensure that we sort of got economies of scale, and equally we can ensure that resources go to where greatest demand is, and I look forward to that. So, here we go. In terms of the contents of the presentation, what I hope to briefly cover is the functions of the ISI, the timelines, the new arrangements, what they actually amount to, the role of the practitioner, the framework upon which they will be working within, and just to refer people to certain aspects of our website. And I think the case that Nolene, that you just mentioned a moment ago reminds me of one of the examples that I quoted at my earlier speech, which is why we are trying to do our level best to set up a service from scratch in literally only a matter of months. I don't disagree with you that what is coming should have been perhaps there several years ago, or certainly quicker than now. But in reality, we have started from a standing start in November, and we're doing our level best to be open by the end of June. But the example that I did quote was just to focus in for a moment on mortgages. And in my mind, there are sort of three key numbers or statistics in relation to that. The first is 800,000, and that's, roughly speaking, the number of mortgages that are out there today. The second number is 150,000, and that's the number of mortgages that are actually in arrears. And then you can go one level down again and look at the mortgages that are in arrears for more than 90 days, and that number is approximately 100,000. But in the same way that your example clearly demonstrated, behind those numbers are people. And arguably, if you look at that 150,000 mortgages that are in arrears, many of those will be taken out in joint names. Many of those will involve families with children and so on. So you could easily see how that 150 is affecting, give or take, 500,000 people. And when you layer on top of that the kind of mental stress issues, mental health issues that email you've quoted brings out, really it is incumbent on everyone who can to bring about these solutions as soon as possible. And ultimately, while we're trying to balance the interest of debtor and creditor in everything that we do, from a debtor's perspective, it is giving them a fresh start, a second chance, because in the vast majority of cases, they're there through victim of circumstance, as opposed to any kind of decisions or any conscious things that they might have done to get into that difficulty. So in terms of the principal functions of the ISI, they are set out in the Personal Insolvency Act, Section 9, and I've listed them here in the order in which they appear. The first three really go to the heart of what it is that we do, which will be to monitor and facilitate the new arrangements, the new alternatives to bankruptcy. And while we have a slightly different role for the debt relief note, in that we will supervise the 3-year period of a debt relief note, the practitioner will remain involved for the others, the debt settlement arrangement and the personal insolvency arrangement, right through to the end. But ultimately, the ISI will hopefully facilitate the smooth running of these arrangements. We are also required to maintain registers of anybody who avails of one of these new arrangements, and that is an issue that has been debated on a number of occasions in the media. And while it is not my role to be setting policy, I think it should be made clear that, for example, there are precedents for this. You only have to look at somebody who's declared bankrupt in the country at the moment. They're on a public register. You only have to look at somebody who's maybe had a debt registered against them. They're on a public register. Just look at Northern Ireland or in England and Wales. They have public registers for somebody who's availed of a DRO, which is similar to one of our arrangements, or an IVA. And I equally asked the Chief Executive of the UK Insolvency Service, who was over only last week, has he encountered problems in operating this register in terms of debtors feeling that they're unnecessarily exposed or any other issues? And he said, frankly, no. He said that he believes it was an appropriate measure to simply reflect the fact that somebody is getting a great deal of debt written off in very many cases. And it is appropriate for creditors who are potentially making a decision as to whether to lend somebody to check whether or not they're within one of these arrangements. So he certainly sees it more as a facilitation to ultimately getting a lot of debt written off, getting that second chance, as opposed to in any way trying to name or shame or have any other sort of objective behind actually having the register. It's also our responsibility to provide information to the public, and I suppose attending at a conference such as this, what we have out on the website and launched through our information campaign last month is 10 examples of that. And we're also responsible for advising the Minister in relation to matters relevant to our functions. And I think the Minister has made clear on a number of occasions that if it proves later in this year that these arrangements aren't working in the way that they are designed to work, or that the overall objective isn't being met, he won't be slow to bring about amending legislation. And certainly from the ISI's perspective, we won't be slow in highlighting any concerns that we might have. We also have a role in authorising and supervising approved intermediaries and personal insolvency practitioners, and that's something that I'll talk on in a bit more detail in a few moments. We've also prepared and issued guidelines, as is our requirement under the legislation, in relation to reasonable living expenses. And that is certainly equally another issue that has received a lot of media attention. And I must confess, from my own perspective, it was frustrating in that when the bulk of that debate was happening, it was before we were launched, before the actual guides were published, and we weren't in a position perhaps to nip some of the misinformation in the bud. But from my perspective, these guidelines do produce two very positive things for a debtor. The first is that it sets a floor below which they should not be asked to live at by any creditor. And when I talk to various people involved in advising debtors up till now, they do have very many instances of where creditors are, in some cases, requiring debtors to live on clearly unsustainable levels. This will prevent that happening again. This, we believe, is a reasonable standard, but certainly not one which somebody should be expected to live below. But the second positive, or the second reason why I think this is important, is that it's actually a fundamental building block to identifying what level of debt is sustainable, and by extension, what level of debt is unsustainable. The equation is ultimately quite simple. You look at what somebody's income is. That's a matter of fact. You take away their day-to-day expenditure, and whatever is left is there to service debt. And if it's not enough, clearly the balance is unsustainable and needs to be dealt with. So as I said, income is a matter of fact. So you need to have some guide or some level of consistency applied to the expenditure calculation so that that formula or equation can be completed. And as I said, it delivers then you to the point where you can identify what needs to be done in terms of the problem debt. Also then we're enabled to provide education and training where appropriate and to contribute to the development of personal insolvency policy generally. So in terms of the timeline, we did launch our information campaign at the end of April. That consisted of a number of guides that go into quite some detail as to what these new arrangements are, and we also have a high-level overview guide which I believe is on the tables outside. We also launched our website. It contains the guides, but it also contains a lot of other information, not least the actual sample scenarios that we have developed for a given set of circumstances to show what we think a particular arrangement might look like. Now, it's not set in stone. A practitioner does have ultimately a blank sheet of paper to work with, but it's just trying to inform the debate, and it's not just to inform debtors but also creditors and others, so that they can actually get their head around what actually might be coming down the line. Information line as well, in terms of the level of interest in that, it's probably 3 to 4 weeks now at this stage. We've had over 20,000 individual hits on the website and over 1,000 people contacting our information line as of now. So ultimately, as I said, we hope by the end of June to be in a position to accept the first DRNs, DSAs and PIAs. And parallel to that, or at the same time, the other provisions within the Insolvency Act, I understand, will be commenced. So that includes bankruptcy reform, the main change of which will be moving from 12 to 3. And Chris may refer to that in a bit more detail later. But we need to do a hell of a lot of work between now and the end of June for this to happen. I've identified just 3 work streams, which I do believe are pretty much our critical paths, but there are literally dozens and dozens. The first one is regulation. We have announced, broadly speaking, what it is that somebody will need to do to apply and get authorised, but we need to publish the regulations. We hope to do that in the coming days, and then we need to start accepting applications and getting authorisations out. Ultimately, I would envisage you're looking at probably several hundred practitioners and approved intermediaries. Very difficult to tell the exact number. Certainly there's been a lot of interest to date at various courses. We will not have several hundred authorised by the end of June or anything close to that, but we will begin the authorisation process in June. I certainly understand there's a number of approved intermediaries ready and waiting. So I think during June we will start creating the list of authorised practitioners, and that list almost will increase on a daily basis throughout the summer as we get through the applications. We've got to complete our IT systems. One of the key developments in that is actually tomorrow, where we'll be demonstrating the application process by way of demonstration to some practitioners tomorrow, just to see how it works. But as things stand today, we will be in a position to have the necessary IT systems in place by the end of June. And we're also working very closely with the court services on a whole host of issues, not least IT systems, to ensure that, again, by the end of June, it's a seamless system in terms of how the practitioner talks to the ISI, how the ISI talks to the court service and ultimately the judge, and back again. And we want to make sure that that's as electronic as possible. I think it's fair to say that probably in most other legal areas you're still dealing with paper based cases, and you often see solicitors and barristers going in with stuff under their arms. What we are proposing in this case is that it will be primarily electronic. The judges will, in the first instance, be assessing the case on their computer screen, as opposed to necessarily any paperwork to support that application. So, as I said, no doubt most people in this room are well aware of what these new arrangements are, but just to very quickly cover them again and explain to you as how I see them. Debt relief note, very similar to a debt relief order, which is very successful in the UK. I see no reason why it shouldn't be here. It is for people with very little income, very little assets, and debt of up to €20,000. The eligibility criteria are quite tight, but ultimately, without any further contribution, you're getting your debt written off. But it is a solution for only a certain category of distressed debtor. The next one is a debt settlement arrangement, almost identical to an IVA in the UK. IVA is very successful in the UK. I see no reason why it wouldn't be here. There's no limits in terms of what level of debt you can involve, but ultimately it does need to be unsecured. And then you have the PIA. That does go further than what happens in most other jurisdictions. It does include secured debt, subject to a limit of €3 million, a limit that can be waived with creditor support. But I think it has to, because we all know the root of a lot of our problems at the moment is property related. And if we didn't have an arrangement that attempted to try and deal with some of these property problems, clearly we would only be tipping the top of the iceberg, or addressing the top of the iceberg. There's a lot of debate as to whether PIAs will work. There's a lot of debate around whether the banks will exercise a perceived veto. The fact of the matter is that when a practitioner pulls together a proposal, a debtor has to support it. So a debtor, in effect, has to vote in favour of it. And a creditor, the majority of creditors have to vote in favour of it. The principle exists in many other situations in the corporate insolvency side. It also exists on the personal insolvency side in the UK. Will the banks vote yes? In my mind, I think they should, and they will, for two primary reasons. One, what's the alternative to them? In many cases, debtors will go, in the result of having a failed PIA, they'll go and seek to declare themselves bankrupt. In that situation, all negative equity crystallises. If you look at it from a creditor's perspective, it's not good news for them. Therefore, they should at least try and deal with as many cases as they can through a PIA short of bankruptcy. Secondly, there are mortgage arrears resolution targets set by the central bank that were announced back in March. And in effect, what they do is say on a quarterly basis how many of your arrears cases you as a bank should deal with, and ultimately how many of those arrears cases you ultimately should have come to a resolution. And those targets increase over time. But if the banks don't meet those targets, they are subject to very draconian provisioning requirements on their balance sheet, and ultimately capital requirements for their balance sheets if they don't meet those targets by the end of the year. So banks need to start dealing with these cases, whatever about whether or not they've been doing them in recent years. Equally, they need to start looking at, well, where's my capacity to deal with this? They are beefing up their teams, dealing with problem loans, personal loans, and so on. But my suggestion is that the personal insolvency practitioner is their easy out to deal with capacity problems that they will meet in trying to get to their MART targets. So therefore, I see this as an efficient and an effective way that if they engage with this positively, that it's in their interest as well as debtors and everybody else. So just for a moment, I'd like to focus on the role of the actual practitioner. And what I'm doing here really is setting out all of the key stakeholders as I see it. And I'm not putting the insolvency service in the middle, because I actually don't see us as being the ultimate critical element of this new process. I do see it as the practitioner. If we don't get the practitioner bit right, the system ain't going to work, simply because all stakeholders need to have confidence in the practitioner. If you take it in turn, a debtor needs to be sure that if they're availing of one of these arrangements, it's right for them, because there are other options, there are consequences to be aware of. Certainly, they're the right kind of thing for a lot of people, but they need to be given the right advice before availing of one of them. The ISI needs to be confident in the PIP to make sure that the opinions that the PIP form are done correctly, that the paperwork that the PIP and the analysis the PIP does is done correctly, and indeed a number of undertakings that we will be demanding of the PIP are stand up to scrutiny. And you could make the same kind of points for the court. The court will be looking at a lot of analysis and reports generated by the PIP. If the court doesn't believe the PIP, doesn't have confidence in the PIP, the court isn't going to find in favour or proceed. And ultimately creditors, as I said, we were talking about the bank veto a moment ago. From a creditor's perspective, I'm going to try and put them under as much pressure as possible to engage in this process. But I couldn't possibly look to demand from them engagement or look for them to vote in favour of proposals if they could legitimately come to me and say the practitioner isn't trustworthy or the practitioner has no experience in this area. So it's with all of those issues in mind that we've gone about to try, within the time limits that we have, within the restrictions of the legislation, to get the practitioner role as right as can be to make sure that this new system works. So in terms of the skill sets that I see relevant for the practitioner, and this equally goes for approved intermediaries as well. Firstly, the ability to deal with people in very vulnerable situations, and it goes back again to the example that Nolan mentioned. They also need to have financial experience and knowledge. They will need to be able to analyse a debtor's situation. They also need to be mindful of a creditor to make sure that they're not being unfairly prejudiced in anything that they're proposing. So they need to do a lot of financial analysis around that exercise. They also need to have some legal background to ensure that they understand what is quite extensive, quite complex legislation, but there's a whole host of other tangential pieces of legislation that they need to be aware of. And I think it's important that they take all of that into account and are able to do so. And finally, there's more of an intangible, which is actually around negotiating skills. As I said earlier, what you're ultimately trying to do here is bring two opposing sides, debtors and creditors, to a table to come out with a voluntary arrangement. So you need negotiating skills to do that, because ultimately you're trying to get to a solution that's in the interest of both sides. So don't expect you necessarily to be able to read this, but it goes into the detail of the sort of unique feature of what we have said a practitioner needs to do to gain authorization. There's all the kind of regular things you would associate with regulation within the financial services industry that I'll touch on in a moment. But what we're saying in terms of the unique aspect here is that a person needs to hold a qualification in law, business, finance, or other appropriate similar qualification to get authorised, and they must demonstrate to the satisfaction of the service that they have the relevant knowledge and experience, and the way that they do that is to have completed a course of study and passed an examination on that before they're actually authorised. And then in terms of the other kind of things that we will be requiring, there's a detailed application form to be submitted. There will be fitness and probity tests. There will be professional indemnity insurance tests. They'll have to have a tax clearance and pay an application fee. And there will also be ongoing supervision, because again, we want to make sure that as this process evolves and hopefully stabilises over time, that we don't take the eye off the ball. We make sure that that practitioner industry is protected for all stakeholders. So again, there are provisions within the legislation and plans within the ISI to make sure that that we deal with those kind of issues. So finally, I just want to highlight our website, isi.gov.ie, and in particular two areas of the website. We have developed this, again, like everything else, in a very short period of time. It certainly doesn't have any flashing lights or any fancy material in it, but what we hope it does do is get across the basic key messages in a way that is easy for the user to see. So as you can see there, at the very centre of the homepage, what we're saying is click here if you're a debtor, or click here if you're a creditor, or click here if you're a professional looking to potentially act in this area. And by clicking into those, you then get the relevant information. But if you do have time, I'd suggest, if you haven't done so already, to look at the left-hand column, which is where a lot of the detail is contained. The first is in relation to publications. They're the kind of guides that we've produced, but also the possible scenarios. And these do go into some detail. We are working on further scenarios that we hope to publish over the coming weeks to deal with more features that we haven't addressed to date. But what we're doing there is setting out 3 cases for a debt relief note, 3 cases for debt settlement, and 3 for a personal insolvency arrangement. And we have then gone a step further in the case that we've selected 1 from each, and then we've tried to break down the steps from a practitioner's perspective to identify exactly what they need to do at each stage in the process. So for example, in the PIA, we have identified about 100 baby points, if for want of a better phrase, baby steps for a practitioner to go through to actually get an arrangement over the line. Now, 100 might sound onerous, but some of them are very basic. It doesn't hopefully scare the reader, but hopefully it will make clear exactly what is expected of the practitioner. So some other documentation there around the prescribed financial statement, and we'll have more on that in the coming weeks, as well as their reasonable living expenses. So that brings me to the end of my introduction to the insolvency service, but I understand there's questions and answers at the end of the session, so happy to partake in that. Thank you.